Title of this case is Delmer Wood versus Brandy Murphy and Theodore Teddy Maines. This is a termination of tenancy from 120 River Drive. The plaintiff, Delmer Wood, is here. The defendants are not here, and I don't believe they ever got served. Mr. Wood, here's what I know. You filed this action to terminate tenancy. You served a notice to quit on the defendants on December 4th, asking them to move out of your house. Now, everybody's in the same house, is that correct?
Well, they're actually out in my garage.
Well, obviously the city won't allow that, but this is right on the river.
Yeah.
All right. Well, anyway, they haven't been served. According to Sergeant Morse from the Southwest Legal Services, I called and spoke to the plaintiff, Delmer Wood, on January 13th. He was explained the procedure for serving the papers on Brandy Murphy and Theodore Maines, and prepayment was explained and requested. He advised he would call me next week and pay the fee. He was advised the papers would not be served unless they were paid for. On 126, I again called Delmer at the number and could tell the call was canceled. I called the number again and it was canceled a second time. I sent a text and he did not call back. He never called or got a hold of me as promised. Papers were sent back to the court unserved. So they haven't been served with a notice to quit or the court papers. Are they still there?
Yeah, they're still.
What happened?
I don't know. They've been trying to move, but I don't know. They ain't been doing too good at it.
Well, I can compel them to move, but we got to serve the lawsuit on them. What happened between you and Sergeant Morse?
I don't know. I talked to him on the phone. He called me. He said he had to have some money to deliver the papers. And then he was supposed to come back or come by or something like that. Going to come by the house.
Well, he called you several times. What I'm going to do. Is Brittany related to you?
No, not really.
How'd they end up in your garage?
Well, my ex-wife, Rosina, was married to her dad.
All right.
And I don't know how it ended up. I got stuck with her. That's not no relation to me at all.
All right. So you served a notice to quit, but they haven't moved. What do they have for heat?
Electric heaters. My electric bill shoots way up.
What do they have for bathroom facilities?
Yeah. I don't really want to say. I don't know.
All
right.
He gets very confused.
I want you to have a seat. What's your name?
Leslie Ann.
Leslie ANN.
Yes.
All right, we're gonna have to continue this because they're gonna have to get served with the notice to quit.
I'm going to get a hold of Bruce today and get everything before we leave here to get that taken care of.
Yeah, I thought Bruce was sent by the house. I thought.
I'm gonna continue this to February 13th. They can't live there, as you know, the city won't let them do it.
No,
Yeah, the city's already served them
they're
with a
saying
civil.
you can't have nobody living in a trailer on your property.
No, you can't. There's not a lot of room between your house and the river.
It gets too much snow, it melts, and that river's right in my yard.
Yes, the river floods in the spring, and you've been there long enough to know. Oh, I don't know where to put this. Continue this to 11:10 on Friday, February 13th. You guys go out to the counter. The clerk can give you information to allow CERT to help get service. But I'm not gonna make you file a case all over again. So you go out to the counter, we'll give you the notice, it'll be 11:10, it'll be by Zoom or live, you're always welcome to come here live. We need to get service on them, we need to get them out of your garage, or the city gives you a big fine.
Yeah, they've already sent the paper, you're threatening.
All right, you guys go out to the counter. Sergeant Morse does an outstanding job of serving all of our legal papers.
I went to school with him.
They
He's a
should.
heavyweight wrestler.
What's that?
I went to school with him. He's our heavyweight wrestler.
You went to Constantine?
Yeah.
Did you? I thought you went to Three Rivers.
I did, so the ninth grade, and I graduated out of Constantine.
Well, he graduated, I think, in 1974. So that was a long time ago.
I graduated in 77.
All right. Well, go out to the counter and they'll help you from there. And Bruce hopefully can get service.
Thank you.
All right,
Thank you.
Miss Banks, your landlord contends that your rent is $1,100 a month, that you owe December rent, a late fee of 30, January rent, a late fee of 30, and a February rent, and a late fee of 30. You also owe $160 in costs and 35 cents, and a water bill of 180. Christine, this makes things go so much faster. I've been struggling with some of the mobile home plaintiffs who can't tell me how what they're asking for breaks down. Anyway, Ms. Banks, the contention is your rent, late fees, and water bill and costs are $3,730.35 through February. What's your response to that?
I'm working with Neighborhood Inc. right now. It was brought to my attention yesterday, though, that she has not, the person I'm working with has not reached out to Carissa yet. So I need to call and check on the status of that. But I guess my situation doesn't really matter, but I've been out of work since September and facing medical issues, and that's how I got so behind. And yeah.
All right. Have you contemplated moving?
With the rejections from the state for assistance, it's definitely, I'm going to be moving in with some family here in the next couple weeks, because I don't, if I do get denial from Neighborhood Inc., I don't have a way of paying yet. I just got a job and I don't start until tomorrow. So it's not working out the way I wanted it to.
Well, the rent's $1,100 a month, and there are 54 units there. So we've been seeing a lot of these. People just get behind and they can't pay it. Well, the law requires that I adjourn this matter for at least 7 days. Today is Monday the 2nd, so we're going to look at Monday the 9th.
Monday the 9th.
Um, 2:20, does that work for you, Miss Yancey?
Yes, Your Honor.
February 9th, 2026. Miss Banks,
Yes.
on that day, the numbers will probably be the same. They won't go up because we're not going to pass into a different month. There may be additional utilities or something, but the bill is going to be close to what it is now, $3,730. I would give you 10 days from that day to pay it. So you would have until February 29th, or excuse me, February 19th. There is no February 29th this year. You'd have until February 9th to move or be subject to being evicted. So essentially, you've got an adjournment of 7 days, and then 10 more days to either pay the rent or move. So keep that in mind. And have Neighborhood Inc. Be sure and contact Ms. Finnerman. Now, some other things I need to tell you, Ms. Brown, these apply to you as well. You have to pay the entire amount. So let's say Neighborhood Inc. gives you $3,000. You would still owe $730.35. The only thing they'll cure it is paying the entire amount. If you do move, you need to turn in your keys, give your forwarding address in writing within 4 days of your moving. I'm losing my voice here. But we're gonna adjourn this for 7 days to next Monday at 2:20. You can come in like Zoom like you just did.
Okay.
And be sure and share this information with Neighborhood Inc. and see what they wish to do. All right?
Okay, thank you.
Do you have any questions?
If I move out, do I still get an eviction on my record?
Depends. You haven't been evicted, excuse me. So it's not an eviction, but it does show that they filed an action. So it won't show an eviction, but it will show they did file a case and it was resolved without an eviction.
Okay.
So if you move out voluntarily, it will not show as an eviction,
Okay.
but it
thank you.
will show they filed a claim. All right, you're right, because an eviction can affect your ability to get the next housing. So it's important to try not to get one. All right, I'll see you next Monday at 2:20.
Okay, thank you, Your Honor.
Thank you, Your
All
Honor.
right.
Just so you know, this is we filed a notice to quit for termination of tenancy. This is not for non-payment of rent on this case.
Correct. All right, Ms. Brown, can you hear me?
Yes, Your Honor.
All right, the title of this case is Finrick versus Brandy Brown and any other occupants at Lakeview Avenue, 107. Miss Finnerman Rarick, what building is this?
615 North Lakeview,
How many units in there?
16.
Who used to own it?
Eric Pearson.
Okay. Miss Brown, they want you to move out. They want to terminate your tenancy and they filed a notice to quit back in November asking you to move. You didn't move, and so they filed this action to terminate your tenancy. I believe your daughter, Kiana Hope, is also residing there. This is a termination of tenancy case, and as such, you have rights. You have the right to hire a lawyer. If you can't afford an attorney, a legal aid attorney may be available to assist you. Right now, our legal aid attorney is en route, and she'll probably won't be here for 40 minutes. You have a right to have, but you can contact legal aid or seek other legal advice or hire a lawyer. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell the court at this first appearance or make the demand in writing within 5 days of today, and be prepared to pay the $50 jury demand fee unless the court waives it for your inability to pay it. You may be able to reach an agreement with the landlord by going through mediation. So far, that's not happened even one time, but it might one day. And you may be able to reach an agreement with a landlord that means the case would get dismissed, in which case they would file what's called a conditional order of dismissal. For example, if you agree to move by a certain date and they agreed to dismiss it or something like that. What's your situation, Miss Brown?
Well, we weren't understanding why we were asked to move. We haven't done anything wrong. We pay our bills there. And after she took over and our lease ended, she just She's
I
been
can't
very,
hear you very well.
she's been very unprofessional and rude and just on me since she just took over the building, and I don't know why. I've not done anything wrong to have to move. I pay my bills. We have nowhere to go once we leave out of here. I guess we've been trying to find somewhere in case the eviction goes through, but renting places are kind of difficult. But yeah, we have not moved because we haven't done anything wrong.
Well, you don't have to do anything wrong. Let's take a look at this.
And I know the lease expired in November and my client timely then served this notice to quit in November, giving them until the December 21st to move. So we're already well beyond the December 21st date.
You had a lease with Mr. Pearson. Hopefully, this new company is going to make some improvements to this building. And maybe they want to get you out because they want to redo your apartment. Maybe they want to get you out because they want to rent it to their brother-in-law. They don't have to have a good reason. Your lease is up. They gave you a 30-day notice to vacate. You didn't vacate, so they filed this action. So it takes a while. They've been trying to get you to move since November. Plus, once they file the notice to quit, they can't collect any rent. So they probably haven't collected December, January, or February's rent. But you tell me what a lot of people tell me. I would move if I had some place to move to. But this is not a just cause termination. It's simply alleging that the lease expired. I had a lady in Three Rivers, lived on Spring Street. She liked her house. She'd lived there for a long time. The landlord wanted to sell it. She couldn't afford to buy it. So he terminated her tenancy and she had to move out. She'd apparently been an ideal renter, but she couldn't afford to buy the house. I'm not sure what FINRA 3's reasons are, but they don't have to have any. We're going to adjourn this matter till next Monday. Continue to February the 9th, 2026 at 2:30. Now be sure you show up on time. If you showed up on time today, I wouldn't have to go through the advice of rights twice. So we're going to do this right at 2:30, but you would get 10 days from February 9th to move or be subject to being evicted. So that's 7 days adjournment and then 10 days to move or be subject to being evicted. Have you been actively looking for a place to move?
Yes, we have.
How much is the rent?
1,100.
Well, you haven't paid at least November, December, January, or February. Probably paid November, December,
No, I paid
January,
November.
February. So you've got several months of rent that hasn't been paid. Now, they may sue you for the rent at some point, but at this point, maybe that'll help get first month's deposit or something in another place. At any rate, we're going to, I'm sorry, go ahead.
I did pay rent for November. I did pay for December. He sent the money back and told us do not pay no more money in that account.
Yes, once they file the termination of tenancy action, they can't accept rent.
So, but we did pay our rent. It's just, she just wants to, for some reason, she has a grudge against me for, I don't know why. And she's been on me since she took over and just has been very rude and unprofessional and just evil, really, for no reason.
Well, then maybe it's in your best interest to move. As you know, you owe the court a bunch of money, but I'm not worried about that right now. You need to try to pay your rent or find a place to live. But if you feel that way about it, it's probably in your best interest to move anyway. All right, we're going to readdress this next Monday, February 9th at 2:30 by Zoom. I don't want you to be late. And if they get what they ask for, you'd get 10 more days, which would be until February 19th to move, or you'd be subject to be evicted. or the sheriff comes and puts your stuff out in the street. Nobody likes that. Now, legal aid is not here, as I indicated, because they're stuck behind a train. But you can contact them. I don't know that there's any legal defense here. They're asking you to move. They gave a notice to quit. Your lease is up. And perhaps they want to redo this apartment. Perhaps they have somebody else they'd rather put in there. I don't know, but they're simply alleging that your lease is terminated or expired, and then it becomes month to month. So they gave you a month's notice, you didn't move, and they filed this action. They've been trying to get you to move since November. It's now February. All right, I'll see you next week at 2:30.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
All right.
Thank you,
Ms. Brown,
Carissa.
I'll see you next week.
you.
Amy Dutka and any others at an address on Buckhorn Road. Mr. Howard Bush is here along with their manager for Lamp and Key, Diana Lamott. We had this case last week and it was continued until today. There also may be a Kyle Wergow living there. That we were served by attachment. They moved to terminate this tenancy because the defendant failed to disclose that she'd been evicted from several previous properties. And I don't know whether Mr. Wergow's on it or not. In addition, they said she never paid any rent after she paid the deposit on the lease. She is not present here today. Let's check and see whether she's here. Hello, Deputy Myers. I'm looking for it. Amy Dutka or Kyle Wergow. All right, thanks. All right, thank you. Bye. They aren't here. Miss Lamont, are they still there?
As far as I know, Your Honor.
Mr. Bush, you've submitted an order. I find by default that the defendant and any other occupants are subject to eviction on or after 10 days from today, which would be February the 12th. No money judgment is entered at this time.
Would we reserve on the money judgment, Your Honor?
Yes, once you get them out, you can seek further money damages. The appeal date is also February 12th. Miss Lamont, this was not a very good deal. You got the tenant in there. They never paid anything else. There are also allegedly 2 children in there. Mr. Wergow is not listed on the lease on the rental application. One dog and 1 cat. At any rate, she didn't come the first time and she didn't come here today, and she's subject to termination of tenancy 10 days from today. Howard, I've signed the order. The clerk will send it out. In 10 days, you can ask Deputy Morse to do the writ of eviction unless they vacate by that
You'll
time.
probably have to do so.
All right, well, he does a good job, as you know. All right, I will see you next time. Thank you.
All right, thank you much. Have a good
Okay,
one.
we've had multiple hearings in this case. A judgment entered in this matter a while ago for termination of tenancy. Ms. Carr is there. Also, her daughter, Shandy Faulkner, and another, Patrick Wiltsey, are there, who they're really trying to get out of the complex. Joining us now are Samantha Sprague on behalf of Mr. Grove, and she's been here from the beginning, which has been very helpful. Also, their manager Cynthia is present. Ms. Carr is here and Meg Bauer is here from legal aid. And I know the parties have been talking, in fact, probably within just the last few minutes. Ms. Bauer, I'll defer to you. What's our status here today?
Thank you, Your Honor. Defense counsel, I'm sorry, plaintiff's counsel. I'm defense counsel. I refer to myself in third person sometimes, apparently. Plaintiff's counsel sent over a proposed stipulated settlement. There are some concerns that we had. I was trying to make my way through it as fast as possible. I received it probably 10 minutes or so after you and I finished our conversation earlier on irrelevant in this case. My understanding is that Ms. Carr has forbidden Ms. Faulkner and Mr. Wiltsey from being on the premises, and that they have not been on the premises, and that a writ was signed by Your Honor and posted on the door, but has not been executed. I don't know that Ms. Carr was notified of the date and time of the anticipated execution. My colleague informs me there was a concern about the ability to execute it with Ms. Carr not being home. I had asked for an estimate of when they thought that might be occurring so that I could help make sure to coordinate that. I didn't get an estimate of when it might be executed, though they did keep me in the loop that it had been requested, signed, and posted, which I appreciate. At this point, we are simply looking at logistics around costs and responsibility for bearing the cost of the execution of that writ, and coordinating how to facilitate that in light of my client's fixed income and the additional burden of court costs already being close to an entire month's worth of rent for my client. So I am hopeful that we can reach resolution.
Well,
but
there is no money judgment here. It's a termination of tenancy to terminate the tenancy of everybody, including maybe it's just Shandy Faulkner and others. But obviously the situation that's prevailing can't continue. Ms. Sprague, what's your take on this?
Good afternoon, Your Honor. I would agree with defense counsel that we do believe that we are very close to a resolution. I am trying to get the physical file brought over right now to confirm, but I believe that typically with our complaint, we do request a money judgment as part of these issues. Nevertheless, even without a judgment, any conditional dismissal would require the repayment of past due rent. And given that this unfortunate situation, it does not fall on my client. My client did not provide keys to the defendant's daughter and boyfriend to
Well,
move in.
I didn't.
We are going to
do,
request those.
I didn't do a money judgment, so there may be further hearing regarding money judgment.
And Your Honor, as Your Honor stipulated previously, there have been numerous adjournments in light of the unique situation that we find ourselves in. At the last hearing on the 23rd, we did provide, I'm sorry, let me make sure my dates are correct. Yes, on the 23rd of Friday, the 23rd, we did provide a copy of the judgment to the court. Immediately, we also contacted the court to see if there was any way to provide payment. We spoke to a lovely clerk that did provide us an online payment tool that unfortunately is not supposed to be used in landlord-tenant matters, which we were apprised of after the fact. So that did unfortunately result in a delay of the writ for that payment to process, which is why the writ was signed on Wednesday as soon as that payment cleared. And the process server did post, but was unable to reach Ms. Carr. We were informed of that earlier today. Given the continued adjournments, we are hopeful for a conditional dismissal wherein payment would be made again for that past due rent, as well as the court cost, and then a probation period. So I understand the court's position is that you typically would adjourn.
Do we
on the
have an
issue.
estimate of what the costs would be? I mean, she was there. Once a termination of tenancy is filed, they can't accept rent, but once the judgment is obtained, they can go back after that rent. So How much rent is due?
Currently, there is past due rent in the amount of $1,375.80, or I'm sorry, $1,110. That does include late fees of $30. We would note for the record that at the first hearing in which we had appeared, which was several hearings ago, Park Forest was, defense was waived by the defense counsel in order for the defendant to pay rent, and no payments have been made since that time. And so again, we would be looking at $1,110 plus court costs, the amount of $275.80 for a total due and owing of 1,300 and, my apologies, Meg, that was a typo, $1,385.80.
And, Judge, just to be clear, those aren't the costs, with the exception of the $30 in late fees that were, that we have questions about. Some of the terms proposed have to do with the costs of executing the writ against Shandy, and those costs we can't possibly know at this time because the writ has not been executed yet. And I guess just for purposes of clarity of the record, all of these judgments that we're talking about are default possession judgments against Shandy Carr and Patrick Wiltsey, but not against defendant Donna Carr.
Yes.
Correct. Your Honor, I do have the complaint in front of me. We did check the box for box 10, indicating that a money judgment is sought.
A money judgment was sought, but I checked the box. No money judgment was entered at that time.
As to
So
the
you'd
default
reserve the
possession.
right to request a money judgment, but I didn't enter it as a part of that.
Correct, Your Honor.
So the defendant doesn't get a free pass on a rent because she's got two unauthorized people in her apartment that are causing all of this turmoil. As you indicated, she's the one that let him in.
Judge, again, we don't dispute
All
the
right.
rents on,
Okay,
with the exception
So-
of the $30 late fees.
all right. So they're late fees, and there's the issue of they're late because I can't pay the rent because of Park Forest.
Exactly.
So,
Well, and
but then there's gonna be a cost of executing this writ, which we don't know what it is. Now, I also have 7 people waiting for small claims starting in 2 minutes. So I can start to address those and you guys can continue to discuss this. But I'm not sure what do you, well, let me ask you, Ms. Sprague, what would you like me to do?
Your Honor, if you could give us a 20 to 30-minute adjournment, I don't know that we'd even need that long. We were making really good progress. Unfortunately, time just got away between my court docket and Ms. Bowers, and we weren't aware until this morning that the writ had not been executed yet.
All right. Laura, would you open the Zoom conference room? And we'll put everybody in breakout. I've got other business to deal with, and then you guys can talk without time pressure while
Thank
I
you, Your
work
Honor.
on these other matters, and then we'll come back to this. It's entitled Teddy McEachern versus James Rund and Catherine Rund. This is a small claims matter for $7,000 regarding the sale of a home and the inspection regarding a septic system. The claim is for the statutory maximum of small claims, which is $7,000. The defendants, James Rund and Catherine Rund, are not present. They've hired a lawyer and removed this matter to the general division of the court, which either party has a right to do. So it's going to be in general civil court with all the rules that apply, rules of procedure, rules of evidence, rules of filing. It takes it out of the small claims arena into the more difficult general civil. So, Ms. McEachern, we are not going to be able to proceed today. We're going to set the matter for a general civil pretrial.
Okay,
We received that January 30th, which was Friday. I saw it this morning. I got date stamped last Friday. So I'm gonna sign the order removing the matter to the general division. Now, what this does, it uncaps the $7,000 ceiling for the claim. When it goes to the general civil, you can sue in district court for up to $25,000. Did they serve that on you, that demand for removal?
I have not seen it as of today, no, sir.
Well, they have to file an answer. They're removing it and they have to file an answer. And the defendant has 14 days from the date of this order to file a written answer. So I signed it just now. And I've yet to see their answer. You can amend you can hire a lawyer and you can amend your claim for up to $25,000.
Okay, I certainly will be amending the claim because my
All right.
expenses have well exceeded the 7,000. Unfortunately,
All
I
right.
do not have the resources to hire an attorney. So am I able to represent myself?
Yes.
Okay, this claim seems very straightforward, so I feel comfortable in doing so.
Well, I haven't gotten far enough into it to know, but at any rate, if you're going to file an amended complaint, I would just wait till you get this removal order. We'll set a pretrial. You can file an amended complaint to sue for up to $25,000 and serve a copy on the defendant, and then we'll set further proceedings. But we're out of small claims and into the general civil arena. So
Okay, so I just wait till I get the information from them and then there'll be directions
Yes.
in there and how
Well,
to
defendant
amend my.
has 14 days to file an answer. So I just signed it today. So today's the
Okay.
2nd. They have to file an answer by the 16th.
Okay. And will I be notified if and when they file an answer?
Yes, they should serve one on you.
Okay.
We're not in small claims, we're in general civil. And if you file an amended complaint, you need to serve it on them. All right. Anyway, we didn't win or lose the battle. We simply changed the arena in which it's going to be fought. So it'll still be me and it'll still be district court, but it will be in the general civil. So anyway, I won't take any more of your time. You'll get the order removing it, and within 14 days, you should get an answer.
Okay. All right.
Thank you.
Thank you for your time. I appreciate it, Your Honor.
All right. That's why I'm here. Thank you.